Well, good afternoon. I will convene the Ohio Task Force on Community Police Relations. My name is John Bourne, the Director of the Ohio Department of Public Safety. I am the co-chair. I'd like to welcome all of you and the members of the task force. At this point, I would ask that Provost and Vice President of Academic Affairs, Dr. Charles Ford, please come to the lectern and provide some welcoming remarks. Doctor.
Good evening. Central State University is excited about the opportunity to host the Ohio Task Force on Community Police Relations. I bring you greetings on behalf of President Cynthia Jackson Hammond, who is in the audience, Trustee Hatcher, who is also in the audience, and we have our dedicated alumni, Mayor Bayless from the city of Xenia. We have our faculty, staff. We are competing at this hour with our students who are having dinner. We welcome you to Central State University, where change is central. As a part of our tenet, we talk about protocol, which is essential to the conversation. We talk about service, which all community police officers participate in. And we talk about civility. The main driving force to understand that the voices in an environment are all equal. We're excited that the governor has envisioned the opportunity to talk about the relationships that exist between our police, our community policing, and the community. Under the leadership of President Jackson Hammond in the last year, we have been inviting our colleagues and community police personnel from around the area to talk about some of these ideas. We want to make sure that the police see our students and faculty as we will see them in a trust relationship. And we've been making strides in that area. Again, on behalf of President Cynthia Jackson Hammond, the administration of Central State University, please welcome.
Thank you, Doctor. Madam President and Dr. Ford, thank you so much for hosting us. If it is agreeable with the Vice Chair, Co-Chair Senator Turner, what I will do is go from my right, far right, with Mr. Munoz, to my far left with self-introductions, and then we will shortly after Senator Turner has some opening remarks, turn it over to Carlton Moore, the Task Force Coordinator, to begin the program. Mr. Munoz.
Good evening. My name is Anthony Munoz, representing Cincinnati. I should say not only Cincinnati, but Warren County. I live in Mason, Ohio, home of Kings Island. But I am thrilled to be here, humbled, and for those of you, I've been here on campus before. It's good to be back on this great campus. Retired NFL football player, and now I run my own non-for-profit. I have a foundation and a couple of small companies, so I'm excited to be here tonight.
Thank you for hosting us tonight. I'm Amy Murray, and I'm representing the municipalities, and I'm a council member on Cincinnati City Council.
Good evening. My name is Bishop George Murray. I'm the Roman Catholic Bishop of the Diocese of Youngstown, Ohio, and I'm happy to be a part of this task force and happy to be here with you this evening.
Hi, I'm Tim Derrickson. I'm a state representative. I represent the 53rd House District, which is in Butler County, southwest of here, and I too am grateful to be able to engage in this conversation.
Good evening. My name is Tom Roberts, a former legislator, member of the Ohio Civil Rights Commission, and the Ohio NAACP Conference Political Action Chair.
Good afternoon. My name is Tanisha Bell. I'm the Chief of the Crime Victim Services Section of Ohio Attorney General Mike DeWine's office.
Good evening. It's great to be back at Central State. I'm State Representative Alicia Reese, President of the Ohio Legislative Black Caucus, and I represent the 33rd House District in Cincinnati, and I'm a proud graduate of HBCU, Grambling State University, where your president attended.
Good evening. I'm Nina Turner, co-chair of this working task force. Really honored to be here and to be with the members who are here traveling the state to come to an understanding about the needs, the wants, the desires of citizens in the great state of Ohio. And we are really doing what the task force name calls for, which is to listen to and hear about community and police relations. We know that we need each other to have a strong community and a strong state, and honored to serve in this capacity, and want to thank the governor again for his leadership in this regard.
Good afternoon. Detective Brian Armstead. I'm a member of the Akron Police Department, and I'm here representing the Ohio Fraternal Order of Police.
Afternoon. I'm Andre Porter, and I have the unique honor of serving as the director of the Ohio Department of Commerce, which is the state's chief business regulatory agency. So I'm pleased to be here. We had a great dialogue in Cleveland several weeks ago, and I think that certainly from dialogue comes understanding, so I'm looking forward to additional dialogue this evening. Thank you.
Thank you. I too am happy to be here. I'm Senator Height from the 1st Senate District, most of Northwest Ohio, 11 counties, a lot of traveling.
Good evening. I'm Dr. Ronnie Dunn, Professor of Urban Studies at Cleveland State University. It's an honor to be here and serve the great state of Ohio on this most important task force.
Hello, my name is Damon Lynch. I'm pastor of New Prospect Baptist Church in Cincinnati, Ohio, and one of the architects of a collaborative agreement between the police and the black citizens of Cincinnati.
Good afternoon. I'm Ron O'Brien, the Franklin County Prosecuting Attorney, which is in Columbus, serving my 5th term as the prosecutor. Prior to that, I served as both the city prosecutor and the city attorney in Columbus. Thank you.
Good afternoon. I'm Mike Navarre. I'm a representative of the Ohio Association of Chiefs of Police. I'm currently the chief in Oregon, Ohio, which is a suburb of Toledo. Prior to working in Oregon, I spent 34 years with the Toledo Police Department, where I was chief for the last 13 years. Thank you.
Good afternoon. My name is Phil Cole. I'm Executive Director of the Ohio Association of Community Action Agencies. We represent Ohio's 50 agencies which work to fight the causes and effects of poverty throughout all of Ohio's 88 counties. Last year we worked with about a little over 800,000 different individual Ohioans.
Good evening. I'm Sheriff Vernon Stanforth in Fayette County, Neighboring County. I'm representing the Buckeye State Sheriff's Association. I'm a 5th-term sheriff for Fayette County. I also serve on the Ohio Peace Officers Training Commission. Currently, I'm the chairperson of the commission. I also serve as the Law Enforcement Advisory Committee for Central State, as well as Southern State Community College.
Good evening. My name is Sarah Andrews. I'm the director of the Ohio Criminal Sentencing Commission, and I'm here representing Chief Justice O'Connor of the Supreme Court of Ohio.
Good evening. My name is Sandra Williams, State Senator from Cleveland, representing Cuyahoga County as well as the Ohio Senate.
All right, is that everyone? Well, thank you all so much for joining us here this evening. My name is Carlton Moore. I'm the Executive Director of the Ohio Office of Criminal Justice Services, and I serve as the task force facilitator. I just want to walk you through the agenda for this evening and share with you some of the rules on the way we're going to operate. First, we will start with a presentation from Attorney Sam Szymanski to talk a little bit about grand jury procedures. Then we will have a presentation from Barbara Bowling. Ms. Bowling Williams is from the Indiana chapter of the NAACP, and she's a member of the National Board. Thank you so much to both of you for joining us here. Once they conclude their remarks, the task force members will have the opportunity to ask questions. So I would just let you know, just get ready, and to warn our experts, they're a tough crowd, so just be ready for that. I want to walk through the rules because once we are done with that portion of our presentation, we will take a short break. And once we come back from the break, that is when you, as members of the audience, will have an opportunity to participate. And we very much want to hear from you. But what we don't want is for you to have to stand in a long line. So what we're trying to do is, if you would like to ask a question, really make comments, share your wisdom with the task force, we would ask that you sign up at the table located outside of the auditorium. You had to have passed it when you walked in. When you sign up, they will take down your name and they will provide you with a number. And when it is time for that public comment period, I will call your number, and when I call your number, please come to the two microphones, one of the two microphones that you see located right in front of me, and then you will have an opportunity to speak. The rule is that you have 3 minutes. You can see this, this clock down that's on the stage. You'll have 3 minutes to share your comment, and we will base that upon the number of people who would like to speak. If we don't have a lot of people who want to speak, it is up to the chairs. They can waive the 3-minute requirement, but last time they were pretty much sticklers for the 3-minute requirement. So with that, let me introduce Sam Szymanski. As I mentioned, Mr. Szymanski is an attorney from Columbus. I do not have a bio for him because he refused to give us one. So thank you so much for joining us.
Thank you, ladies, gentlemen, audience members. So I'm really not sure what you want to hear. I do know that the topic is grand juries, grand jury procedures, maybe how they're used, maybe how they're misused, maybe how they could be reformed or changed. But just a little historical background. The right to a state grand jury is provided by the Constitution of the state of Ohio. If you're charged with a federal crime, you've got a federal constitutional right to have your case heard by a grand jury before an indictment could be returned. But in Ohio, we're fortunate enough to have a constitutional requirement, not all states do, but Ohio does, that requires the prosecutor of each county to convene a group of individuals, usually between 9 and 15 or so, who determine whether or not probable cause exists to believe a crime has been committed. Now, I hesitate to say my county, but the county where our firm's practice is concentrated, Franklin, Ron O'Brien, Ron, raise up your hand there. He's our elected prosecutor, and he runs a grand jury, he and his office colleagues, 5 days a week, 365 days, or 52 weeks a year. So our grand jury is constantly meeting. And prosecutors, generally younger prosecutors who are working their way up the ladder, come in with a stack of files and they meet the grand jurors and they present whatever evidence they believe is appropriate in order to get somebody charged, indicted. Now, as I walked in here today, there were some banners held up about the poor guy at Walmart that got killed, whose name I didn't know, but when I asked, I was told. There you go. And the concern in a case such as that is not how does a grand jury prevent wrongly accused people from being charged, but rather how does such a body ensure that people who deserve to be charged are actually charged. So it's sort of a reverse concern. We're not worried about wrongly accused people being charged. We're worried about wrongdoers escaping criminal responsibility. And all I can tell you is that that is certainly a shortcoming, at least a perceived shortcoming in the process. But it's important to remember that elected prosecutors in smaller counties have a difficult razor's edge to walk in that they often work with police officials and police officers and detectives and patrolmen. And it's difficult, I would submit, sometimes in a smaller municipality for a prosecutor who is also elected and may have a certain community expectation to not be pressed or felt as if he or she is tugged in many different directions in a case such as the one where the man is shot at the Walmart store. And thus the question becomes, John Crawford, forgive my lack of information. I'm not trying to be disrespectful. Well, I don't lack empathy, but that's okay. That's for another time. You're allowed to express an opinion. You're excused. But the point is, when Mr. Crawford is shot and there is a demand for scrutiny and maybe a demand for an indictment, the grand jury system as we know it is convened, prosecutors present evidence, and then an indictment is returned or not returned. And I'm not here to weigh in on whether or not anybody deserved to be indicted or not. I'm sure there's a lot of opinion in this room about what the appropriate result should have been. I can tell you, however, that at least in my experience, having defended people accused of crimes for almost 30 years, including police officers, that at least in Franklin County, nobody escapes scrutiny, nobody escapes indictment because of their position or because of the color of their skin or because of their job. Whether that's true in any other county, I can't weigh in, but I can tell you that at least in Franklin County, our experience, or at least my experience, is such that the process works pretty well. And maybe that's because we have almost 1 million residents, maybe it's because we have a prosecutor who takes a different approach, but that's at least how it works in Franklin County. As most of you are aware, in Ohio, grand jury testimony is secret. Witnesses take an oath, which requires them to not share their testimony, and that serves multiple purposes, including making grand jurors feel comfortable about testifying in cases that might be otherwise difficult. So that's an overview of the grand jury system in this state, and I'm sure we'll have plenty of opportunity to discuss how it functions and maybe how it doesn't function or whether it's dysfunctional or functional. But with that, I think I'll sit down and let my colleague, who's going to talk next, offer a few words, and then I presume we'll be available to take questions from, I guess,
we can take questions now for you.
Okay.
From the task
from the
force
audience
members.
I'm sorry, Carl?
From the task force
members.
members.
From the task force, okay.
Right.
Anybody have any questions? Ma'am.
Thank you, Madam Chair. Mr. Szymanski, let me ask you not specific general questions, because you said it's in the Constitution. What does the Constitution specifically say about a grand jury?
The Ohio Constitution?
Yes.
Specifically, maybe it's helpful to repeat the oath. Do you solemnly swear or affirm that you will diligently inquire into and carefully deliberate all matters that shall come to your attention concerning this service? And do you solemnly swear or affirm that you will keep secret all proceedings of the grand jury unless you are required in a court of justice to make disclosure? And here I think is an important phrase, if the words mean anything, sir. And do you solemnly swear or affirm that you will indict no person through malice, hatred, or ill will? And do you solemnly swear or affirm that you will not leave unindicted any person through fear, favor, affection, or for any reward or hope thereof? And do you solemnly swear or affirm that in all your deliberations you will present the truth, the whole truth, and nothing but the truth? So that's the oath that's taken. Whether it means anything in practice, I don't know. But if I were to sit down and try to draft an oath that said, hey, let's be fair, that's a pretty good start.
So is it silent on the role of the prosecutor in the grand jury?
Well, I mean, I think the role is pretty well defined, but you know, the proceedings themselves are secret. That's true, unless you can show a particularized need to have the testimony revealed.
Well, thank you, Madam Chair. I think the question people would ask is it necessary for the prosecutor to present to the grand jury, or can the grand jury become a fact-finding body in and itself? So is the Constitution silent on the relationship between the prosecutor and the grand jury?
Actually, Prosecutor O'Brien is going to take this question. Thank you, Ron.
Yeah, if I could, I think you're correct. The Constitution is silent on that issue. I can't think of any other way that the evidence would end up being presented to them. I think the prosecutor has statutory duty to represent the state of Ohio in all criminal proceedings in the county in which they're elected, one of which is a duty to present cases to the grand jury. So I think that some states have a more independent, if that's the nature of, I think, the question, more independent ability, sometimes under the direction of the prosecuting attorney, but generally in Ohio, the prosecuting attorney presents the cases and listens to the grand jurors, what they may want to hear. I think the statute specifically provides that the prosecutor shall inquire into crimes committed within the county in which he's elected or she is elected. And then secondly, I think it provides the grand jurors separately have the ability to have information presented to them, but they also don't do it separate and apart from the prosecutor.
And Ron, wouldn't it be fair to say that, at least with respect to your experience, grand jurors ask questions all the time of witnesses, questions that you may not have asked or that one of your colleagues may not have asked?
But I think, Prosecutor Bryan, you answered what I was asking, because there are many people who wonder, because, as you've pointed out, Attorney Szymanski, the close relationship between the police department and the prosecutors, if there can be a separate presentation, especially when a police officer is involved, a separate presentation made to the grand jurors, which are citizens like any other jury, made on behalf of the citizens. I think the answer is that somebody in the legal world could present to a citizen grand jury the information without it being a prosecutor per se. Is that correct, Attorney O'Brien?
I don't think anybody can appear before the grand jury unless requested by the prosecutor or requested by the foreman or forelady of the grand jury. I think we have had occasions where a foreman or forelady will request certain information be presented, and we will honor that. And in fact, in the kind of cases that are under scrutiny of this commission, what we do is we write a letter to the deceased family or their lawyer or other representative prior to the case being scheduled before the grand jury, asking if they know of any witnesses that have not been interviewed by the police, have not otherwise come forward, and ask that if they desire to testify before the grand jury and are not, for example, in the police investigation, a request that they provide the names of those witnesses. We will have those witnesses interviewed prior to the scheduled grand jury date, and we'll actually present any witnesses that are provided to us. Frequently, the deceased representative families, even if they're not present at the scene of the incident itself and may not have personal knowledge, we permit. And as I say, I'm speaking for Franklin County and can't speak for the other 87 necessarily, but at least that's our practice.
But Ron, the real answer to the question is no. The only person that decides what to present is the county elected prosecutor. And if Prosecutor O'Brien takes a more expanded approach saying, hey, decedent's family, tell me what you have, what have we missed? That's great, but the question becomes, in a county that's not as enlightened or with a prosecutor who is less focused on justice, you could have a situation where important evidence is not presented in order to meet an agenda or a perceived notion, and that's where you run into problems.
Let me just ask one question that I'm thinking. I'm sure what I heard, however, was that we have to have a grand jury. What I have not heard specifically, the Constitution says that the prosecutor has to present to the grand jury. If the legislature would present another form of presenting evidence before a grand jury, it would not be in violation of Ohio Constitution. I don't believe so.
I think that's correct. And correct me if I'm wrong, but I presume what you're suggesting is, hey, let's say we have a serious situation like the one at the Walmart, and we want to have an independent, sort of like a special prosecutor, an independent counsel, or somebody who may not be as tied in and could make...
I think what I'm asking has been answered, because there are a lot of people who believe that the prosecutor is not representing the people.
Right.
And he or she is out for their average, you know, of 50%, 51% convictions, as opposed to presenting and letting the evidence take it where it will. But I thank you, Madam Chair. I think a question's been answered. Thank you.
Mr. Szymanski, can an ordinary citizen who may have information about a particular alleged crime, can that person come forward to the grand jury and testify, or does that person have to be invited to testify by the prosecutor?
Has to be invited to testify by the prosecutor, because the grand jury is run by the prosecutor. Period. Plain and simple.
So if I, for example, have information about a crime, am I free to contact the prosecutor to say that I would like to testify before the grand jury?
Absolutely. And I guarantee you, Bishop, if you picked up the phone and had Ron O'Brien on the other end and said, hey, look, I was a witness to this, he'd say, come on down, in a heartbeat. Now, whether you would get that same response from other elected county prosecutors, I don't know. But you certainly, Ron would be out of his mind, and he's not out of his mind, to ignore evidence such as that. Because his goal is to present evidence. But you don't have a right as a private citizen to testify in front of a grand jury unless and until you're invited, unless you're subpoenaed and called as a witness.
Okay. Thank you.
Yes, sir.
Senator Williams.
Thank you, Madam Chair. Since we've been having so many incidents in our communities and across the United States, some of my constituents have come to me and asked to submit legislation to the Ohio legislature to do a couple of things. One, to abolish the grand jury in Ohio. One, to abolish the secrecy of the grand jury, and to also make available the transcripts from the grand jury. Some people believe that there is not enough transparency in the grand jury process. Other things that have been brought to my attention is maybe the prosecutor is not presenting all the evidence, the real evidence for the grand jury to come back with an indictment, or the prosecutor may not be asking for an indictment. That's been brought to my attention a lot. So my question is, when I submitted my information to the Legislative Service Commission, they said that the legislature did not have standing because it was given to, the authority was given to the Supreme Court. My question is, do you believe that the grand jury process is still a valid way to bring charges against police officers? And number two, have you all had any conversation, any prosecuting attorney, with the Supreme Court about looking at the old laws in place and whether or not Ohio should revise those laws?
Senator, let me answer that in a couple ways. First of all, remember that the role of the grand jury is to prevent people from being wrongly accused. The issue that your constituents have is a grand jury behaving in an opposite fashion, protecting those who should be accused. And so the question is, how do you remedy that situation? Is it in the vast majority of cases? No, it's in the very high-profile minority cases. And rather than turn the whole grand jury system on its head and worry about the procedures, the question is, who could make the proper presentation in, say, a police shooting case? Who's the best person to run the grand jury at that stage? Is it the prosecutor who works with the police day in and day out? Or is it somebody who's more independent, that doesn't have the same conflicts, whether real or imagined, and can still present a case and make sure that justice is done without kowtowing to any constituents, whether it be the fraternal order of police or an angry group of people who feel they've been wronged? Because the question is what's just. And so the grand jury is really designed not to weed out the people that deserve to be indicted. It's designed to protect the accused, and that's why it's a little bit of a difficult vehicle to solve the problems that are bothering so many of your constituents. So I think the answer is that if you were going to take a legislative approach, you might say that in certain situations, such as police shootings, maybe a county prosecutor isn't the best person. The next question becomes then, who is? And that's something that legislators will have to grapple with, and I think it's a very, very difficult question because, you know, you want to give validity to the people who have elected your prosecutor and hope that he or she is a righteous, justice-seeking individual. The problem becomes when that perception gets lost in the conflict or in the difficult cases, as we have at the Walmart. Like you scratch your head and say, what? Or you got a 13-year-old kid in Cleveland gunned down within 2 seconds of somebody getting out of a police car. And I'm not passing judgment, I'm just saying it certainly raises issues about whether or not the grand jury system is effective in those types of cases. Apparently, I think overwhelmingly the answer is no.
Follow up, Madam Chair. Okay. The people in the state of Ohio, some people have a distrust for the legal system. So the question again is, have you all had a conversation with the Supreme Court about looking at the rules that are in place right now? So that's the first question. And then the second thing is, what is the system of checks and balances to make sure that everybody is acting in an appropriate manner when presenting evidence before the grand jury?
Well,
is there a system of checks and
no,
balances?
the answer is no. There's no system, and we have to rely upon the elected official that is in charge of doing the right thing. And that's when you boil it down. When you elect somebody to be a prosecutor, you're not electing somebody to convict every man or woman that walks the face of the earth. You're electing him or her to follow the law, period. And it's when people get twisted around and what that means that you have problems. So it's not really a procedural issue we have here. You know, you can get rid of a grand jury and maybe do it some other way as other states do, but in Ohio we have a constitutional requirement for a grand jury. And there's nothing wrong with that. Where it gets lost is when people feel like there's an agenda in place. And that's when you lose trust in the system. And I think it's an easy leap to say that anarchy isn't very far behind. I mean, you can see that in Missouri with businesses being burned and people being injured and all kinds of fallout from, pardon? Oh, okay, I'm sorry. So yeah, I appreciate the question, but the answer is I don't think there's any dialogue going on currently with the Supreme Court to make any substantive or procedural changes to the grand jury system. You also mentioned secrecy. I'm going to submit to you that secrecy is not the problem. It's who's presenting the information.
And final
Mr.
question,
O'Brien, Mr. O'Brien has a question. Well,
Okay.
right back to you. Senator Turner's taking this side. I'm taking this side.
Okay.
Yeah, I would say the answer, could you abolish the grand jury? Many states don't have a grand jury to charge crimes. They only have it to investigate crimes. I think you would need a constitutional amendment because there is the Constitution that says no felony case shall go forward absent a waiver by the defendant or an indictment by a grand jury. So I think the reason LSC would not draft something to abolish the grand jury is the defendant has a right to be indicted by a grand jury, or you couldn't have any felony case go forward in Ohio. I think you could ask the Constitutional Review Commission that's studying different things to recommend the Constitution be amended to permit felony charges to be filed by a prosecutor as opposed to going through a grand jury. But again, I think as Mr. Szymanski says, I'm not sure that gets to the root of the concern. I'd throw in two other observations. The grand jury is ultimately under the supervision of the Court of Common Pleas, and at least in our county, it's the administrative judge that excuses them, orients them, gives them their instructions of law, much like a petit jury. And I think that some things could be done by the court. In fact, since some of these issues have arisen, I've talked to our administrative judge about whether or not in these kinds of cases, certainly not in all cases, but in these kind of cases, whether or not having a judge actually sit through the grand jury proceeding and preside as the judge so that there is that other layer of judicial impartiality in the grand jury room that some people have a concern isn't there. I think the court could do that. and the Supreme Court probably wouldn't need to adopt a rule or have a statutory amendment. But ultimately, the issue of the prosecutor being either biased, having a conflict of interest, or some other problem, there are statutes currently that allow the Court of Common Pleas to appoint a special prosecutor if that is deemed to exist in a particular case. And at least in some cases, prosecutors among themselves across the state make that decision. For example, I handled a police shooting that happened in Fairfield County in the city of Lancaster by a Lancaster police officer, where someone, as Mr. Szymanski indicated, people know each other much better and may go to church. The prosecutor may go to the same church, or his kids may go to the same school as the police officer who engaged in the shooting. So I was asked to handle that. Other prosecutors, I know Tim McGinty, the prosecutor in Cleveland, handled a case in Richland County or Mansfield not earlier this year, last year, where that kind of issue arose. So amongst ourselves, I came to Greene County actually a couple years ago as a special prosecutor, where, not in a police shooting case, but another case where the prosecutor felt he had a conflict of interest. So prosecutors exercise the ability to recuse themselves if there is an issue that creates a conflict, and there is a mechanism, through cooperation where other prosecutors handle them. The Attorney General's office, I know, has a special prosecution unit where the case can, if the prosecutor be recused either by the court or by themselves, that office will handle these kinds of cases. So all of those options, I think, are out there currently and both available and used. Finally, on the issue of transparency, certainly the court rule provides, as well as a statute, that all proceedings in front of the grand jury shall be secret. The purpose, obviously, is if someone's suspected of child sexual abuse and the grand jury should choose not to indict them, they would never have the chance to go in front of a regular jury and have their name cleared through an acquittal. That's the purpose of secrecy, to protect the suspect that is not charged. In these kinds of cases, that rule really isn't applicable, because everybody knows by the time it goes to the grand jury who the officer was that is alleged to acted improperly, and there might be mechanisms where the rule or the statutes could be amended to permit greater transparency in these kind of cases, because the general purpose for which secrecy is designed is not really present.
Thank you, Mr. Prosecutor. Senator Williams and then Representative Reese.
Okay, thank you, Madam Chair. Just one final question. Prosecutor O'Brien mentioned that in some states they don't have, well, the grand jury is used to investigate crimes. So I guess my question is, if 23 or 26 states don't have a grand jury, what process do they use to determine whether or not they're going to charge? Is it this investigative unit for the grand jury, or who is it up to decide whether or not to bring charges against someone?
Well, and that's what the problem is. It depends on the state, but generally the body about which you speak does nothing more, but does issue subpoenas and gathers information, which they then pass on to a prosecuting authority. So there's really no filter, there's no consensus, there's nothing. It's just an information gathering system. So even though it sounds as if our system isn't very progressive, it really is when compared to other states without it. And even though there are shortcomings in the system, it's still designed, and as Ron pointed out, it's especially when people are not indicted, that information stays quiet. So you're not embarrassed by allegations, and it's as if you were already convicted once the news gets out. As you're well aware, once it hits, there's no way to get it back. So, at least Ohio has that filter, although it may be very porous sometimes, it's still in place. So, rather than just having a police officer or one lone prosecutor make a decision as to who has to run the trial gauntlet, at least you've got this protection, I would submit. So before you and your colleagues decide to throw the whole thing out, at least, I don't think you can without a constitutional amendment, but if you wanted to render it less effective, maybe you could, but the fix is not in the institution, it's the way in which the evidence is presented to that body of people. I would submit. Ron?
Mr. Chairman, I might add that in those states that don't have a grand jury, the decision is made by the prosecutor. They collect the evidence, they submit it to the prosecutor, and that prosecutor's office decides whether or not the evidence is sufficient to file a charge. And they typically do it by what's called a bill of information. It's just a charging instrument, the same as you file a complaint in municipal court in Ohio, or an indictment's returned by a grand jury in common pleas court. It's the piece of paper that gets filed by the prosecutor to say a crime has been committed, this is a person that committed it, these are the nature of the charges, and then it's served on the suspect. So it is, I guess, less of a protection for either assuming that someone has committed a crime and is unjustly avoiding prosecution, less of a protection against that. On the other hand, it is also less of a protection to have an overly aggressive prosecutor be filing charges not supported by the evidence. So on both sides of that coin, it's solely and exclusively the prosecutor's decision to file this bill of information or not.
Thank you.
Thank you. First of all, I want to thank you, Attorney Szymanski, and thank the task force for tackling this issue of the grand jury. It's kind of been the elephant in the room, particularly after the case that we've seen with John Crawford and also what we will see with Tamir Rice. And after the grand jury came back, the presentation by the special prosecutor, because some would say that if we had a special prosecutor, that would be the answer. It was not the answer in the case of John Crawford. Some would say if we just had videos, we had over 200 videotapes, that wasn't the case. And then in the presentation by the prosecutor, it's almost like he came off as a defense attorney. My question to you is, you've indicated that the prosecutor has a lot of control. In the 88 counties, and certainly, are they, you know, we have some concern that there aren't any African-American head prosecutors of, you know, that will be in the room presenting this case, and that the fact that it's private. Can you maybe talk to that for folks? I know that's what I've been hearing from people saying, how do I know that my case is really being presented? I've talked to the family of John Crawford who feel like that their case was not presented in this closed door process. Who's standing up? Who's speaking for them? Can you talk about the importance of maybe diversity or any recommendations that you've seen or heard about that might help contribute to restoring that faith in that closed door setting?
I can. And so the real answer to your question, the no BS answer, is that for Mr. Crawford, nobody spoke for him. Now, you further politicize, I say you, the system picked a special prosecutor. Now, who knows who did that picking? I don't know. I don't know if it was independent. I don't know if it was a result-oriented pick. And I have not seen these videos, but my colleague, as we drove over here, said, oh, she'd seen the videos, and it was clear that this guy is talking on his phone, and the cops come in and light him up, and he's deader than a doornail, and nobody cares. But the truth is, people do care, but unfortunately, the folks that were in the decision-making process somehow felt that there wasn't even sufficient probable cause to indict. Because remember, at the grand jury level, we're not talking about proof beyond a reasonable doubt, we're just talking maybe. Is there sufficient evidence to go forward and have this man or these men or these people answer to this in a court of law? Well, they will have every constitutional protection afforded to everybody else. So is it surprising that the African-American community is suspicious? No, they should be. And when you have everything on a videotape and you have an acknowledgement, I guess, from one of the persons or one of the people who made the 911 call in that Crawford case that maybe they were lying about the fact he was waving a gun around, you further scratch your head and you say, where is the justice? Well, the answer is, presumably, and I don't know anything about it, but from what I've heard, there's no justice in that case because it didn't even move forward. It didn't even get into the realm of a jury trial where everybody would have a lawyer and people could present evidence in a form that was anything but secret. So the answer to your question is there's no justice there, and regrettably, apparently, there isn't going to be any. Now, that doesn't mean that the case couldn't still be presented again at a later date. Maybe there'll be additional information, maybe other ways of thinking will, become paramount, and there might be some measure of justice, but right now you can, I think, regrettably forget it. It's non-existent. And how does the family of Mr. Crawford feel? I think aggrieved. How does any citizen in this state, how should they feel? Aggrieved. The question is, what do you do about it? And unfortunately, in that case, the answer is nothing at this point.
Follow up. I guess that's the reason that we're here. And I know a constitutional amendment, at least the people would have a chance to vote on it and decide what that is. But can you tell us, is our system, we always have to make improvements in your background, because we can't keep having this happen and just say, okay, let's move on. I don't think any other group would allow it to just move on. Is there anything that you think could be tweaked, even if, it has to go to the voters, but we'd like to do something sooner rather than later? But is there anything in your research that can, and that's the kind of things that we're looking for, that we can have some diversity in those grand juries that has the experience and the background and maybe more sensitivity toward, African-American males in these kind of situations?
Let me answer this two ways. One, Carlton said I didn't provide a biography because I think they're BS. You don't need to know my background to listen to what I'm going to say and judge it based on the words that come out of my mouth. But what you're looking at is east side of Columbus Jew that was raised in a family where people didn't talk about color. It never existed. So I didn't grow up as a bigot. But there are certainly, in this day and age, still plenty of bigots out there, and people who feel that it's okay maybe for white cops to shoot unarmed black kids or a guy holding an airsoft pistol. That is a mindset, and unless and until that mindset gets erased, it's going to be a problem. Now, you're asking me, based on my experience, do I ever see that come into play in the justice system? And I'm going to tell you, in Central Ohio, no. And I'm not trying to kiss Ron O'Brien's ass. The answer is no. And I represent people of color all day long, whether they be police officers. His office has indicted more than one, in my opinion, innocent police officer, white and black. So they're equal opportunity employers. They'll indict anybody that they think has broken the law. But that's a luxury we enjoy in Columbus. There's our system. We've got plenty of African-American judges, plenty of female judges. We've got plenty of diversity, and our system functions well. It's when you get outside of these major metropolitan areas where you still have a lot of inbred racism that you're not going to get away from it. And I don't think there's a legislative fix in the world that's going to make a difference, because one fix isn't going to help all of 88 counties. What works down in Butler County may not be working well in Columbus, Ohio. So I don't know what the answer is. I wish I did. But I think that the issue is who's doing the presenting. The next issue is who are your grand jurors? Remember, they're going to be from the county in which the crime is alleged to have occurred. So if you're in a rural, all-white county with some, white police officers that have shot some black man, you may have people that just don't care. And how are you going to legislate that away? I don't think you are, unfortunately.
All right, I hate to cut off the, we have questions. Okay.
Yes, thank you, Director. Mr. Szymanski, I'm from Cuyahoga County.
I'm sorry, I'm a little hard of hearing. I heard you're from Cuyahoga.
I'm from Cuyahoga County, from Cleveland, and I wanted to know, one, does the Franklin County, do you collect demographic data on the cases that are prosecuted? You state pretty definitively that you're sure that there is no racial bias in the prosecution or handling of cases in Franklin County. And with all due respect to Prosecutor O'Brien, I just question the validity of that statement, particularly when we look at you're suggesting that there might be some bias in rural counties. Well, once again, I'm from Cuyahoga County, and I do know that bias operates throughout the criminal justice system, both in rural and in more metropolitan or urban areas.
Yes, sir. What I can tell you is anecdotal, but I mean, I've represented thousands. My criminal practice in Columbus is big. I just don't handle a case here and there. It's all I've done for literally almost 30 years. And I have never, ever, ever, ever had race be an issue. Never once. From representing Jimmy Jackson, Santonio Hall, it's all public record. I can talk about these folks. Now, these are athletes, down to crack dealers, sex offenders. The color of your skin isn't going to make a difference in Franklin County. The size of your wallet might, but it's not going to be the color of your skin. Now, do I have definitive statistical data to back that up? No. But I'm just telling you, being in those trenches day in and day out, nobody cares about the color of your skin. Sorry. And that may not be what people want to hear, but we are lucky in Columbus, Ohio, that our judges don't think that way. People aren't sentenced that way. I don't get stiffer sentences for people of color than I do for white people. It just doesn't happen. That's fine. That's what we're here for.
If we, yeah, can we, to my sisters and brothers in the audience, the task force members are asking the questions of the experts, and we know that everybody has some highly charged feelings regarding these issues, which is why this was the topic that we selected particularly to come to Central State with. When the task force is done engaging and we take a quick break, members of our community will have the opportunity to engage as well. But we are asking that we do everything decently and in order, and that means not shouting out to the presenter. Thank you.
Chief.
Thank you, Mr. Chairman. I have a quick comment and a quick question. My comment is, I've seen it both ways, with a grand jury, without a grand jury. I've been chief for almost 17 years. I've had to supervise the many investigations involving officer-involved shootings. My first year, 1999, we had 5 officer-involved fatal shootings, none of which was presented to a grand jury. None. The prosecutor made the decision. She took tremendous heat. I took tremendous heat as the chief of police. At some point, maybe 3 or 4 years down the road, we decided that we were going to present every officer-involved shooting to a grand jury, and the process was 100% better. Many were with controversy, but having a neutral body look at it, other than just a police department and a Lucas County prosecutor, was a much better system than not utilizing the grand jury. My question is a simple question. Can a police officer be compelled to testify before the grand jury?
No. Against himself?
What if he is granted immunity from that testimony in a criminal trial?
Well, if Ron O'Brien grants a police officer transactional or use immunity against himself, a shooting police officer who kills somebody?
Well, he can take the Fifth Amendment during a trial, but can he do that also in a grand jury?
You can also take the Fifth in front of the grand jury.
Okay. Thank you.
Yes, sir.
Bishop.
Thank you. Aside from voting someone out of office, is there any established judicial review for a prosecutor?
No. Nope.
None at all?
Zero. They're elected unless and until they get their law license yanked or get voted out, they're in.
Thank you.
And just let me add, you don't want them to kowtow the other way, right? You want somebody that's going to be independent. It's like a tenured professor. As long as they serve at the will of the people, you don't want them to be worried one way or the other. You don't want them to also be worried about indicting that officer in a rural county and having the constituents call for his or her head. It works both ways.
Okay, I'm sorry, but we're going to have to end the discussion there. Thank you very much, Sam, for your presentation. And I'd like to call up Ms. Bowling Williams. Now, Ms. Williams joins us. She is the head of the Indiana NAACP, and she also serves on the National Board of Directors of the NAACP, and she chairs the Criminal Justice Committee. So thank you so much, Ms. Bowling Williams, for joining us here today.
Thank you for having me. and thank you for giving me the opportunity to give testimony before this August task force. We really have to commend your governor and the people who lit the fire up under him to convene such a body. This is a most important topic and critical situation. We have a report that was put out, that was launched in September of 2014 called Born Suspects. It's located on our NAACP website, and it is a document that is a very easy read. It's not very long, it's user-friendly, and it was implemented to be a tool to assist our advocates in the field in helping them eliminate racial profiling in America. And so I encourage that if any of you want to know more about this topic and about the report, that I'm going to be just sharing a few of the things that are contained in the report, and then I've got some additional comments of my own that I'd like to make. The report centers on the continued efforts to eradicate racial profiling and the successes realized recently in New York City. The survival of our republic depends on success. Our children deserve a future where they are not judged or stereotyped by their race, ethnicity, nationality, religion, gender, gender identity, or other inherent immutable characteristics. This was a quote from a statement that's made by our national chairman of the board, Ms. Rosalind McAllister Brock. Racial profiling by law enforcement, the targeting of individuals as suspicious based on a set of characteristics they believe to be associated with crime, rather than credible evidence or information linking a specific type of person to a specific criminal incident. Attention was sparked in 1991 following the beating of Rodney King. Incidents continued through to 2001 with the shooting death of 19-year-old African-American Timothy Thomas by police officers in Cincinnati following a hot pursuit. This led to increased conversations regarding the hope of legislative change, but that was before 9/11. After 9/11 attacks, it derailed any efforts that had been made toward eliminating the use of racial profiling as a law enforcement tool. This tactic has proven to be ineffective and inefficient. Instead of being used as a tool, it appears to have now become the law enforcement weapons of choice. After 9/11, there were 1,200 people swept up in the streets of New York by law enforcement, individuals of Muslim, Middle Eastern, or South Asian descent. The only charge that were ever brought against any of these people were for minor immigration violations. Similarly, more than 80,000 people registered through the NSEER program that required foreign visitors to report to immigration offices to be photographed, fingerprinted, and interrogated. There is not any evidence that any of these people were identified as terrorists. History, too, has shown us that racial profiling is not effective. Just one example of how it failed, go back to the year of 2002 during the DC sniper attacks. Relying upon standard profiling techniques, law enforcement was looking for a white male acting alone or with an accomplice. They were planning to question al-Qaeda prisoners at Guantanamo Bay. But in the meantime, the African-American man and youth responsible for the attacks were able to go unapprehended despite coming into contact with law enforcement at least 10 times. In 2004, there was a report by Amnesty International called Threat and Humiliation. They conducted a poll that showed that approximately 32 million people reported having been racially profiled or some type of profiling in their life. That number is equivalent to the population of Canada. Stop and frisk numbers in New York City. In 2011, the New York Police Department conducted 685,724 stops. 88% of those stops did not result in any type of arrest or even a summons being issued. So you see, racial profiling really doesn't work. There's a human aspect also attached to this. And there are several examples in the report. But I kind of wanted to highlight one in particular, and this was under a section that talks about law enforcement officers and elected officials. And one particular law officer had indicated that he had been racially profiled while off duty. But while he was on duty one day, he was told by his commanding officer that they have a quota that they had to reach. So many people that they had to arrest and to stop and to frisk. And there were a group of young kids, African-American kids, standing on a corner, and his superior told him to go handcuff a 13-year-old boy who hadn't done anything. That was a turning point from him. This young boy's brother came up on the scene and asked, "What's going on? Why is my brother being handcuffed?" And they handcuffed and arrested him as well. Things have got to change. There is a need for meaningful anti-racial profiling laws across this country. 20 states have no explicit law banning racial profile. And I can tell you, Ohio is one of them, and my home state of Indiana is another. 17 states have banned pretextual traffic stops. 17 criminalize violations of their law. 3 states require mandatory data collection. 15 require analysis and publication of that data. 17 states require creation of a commission to review the data and the complaints, and also to review citizens' complaints. In 2013, the New York City Council passed 2 of 4 bills that had been put forth to end racial profiling in their city. 2 of them passed, one in the Indiscrimination Profiling Act and the New York Police Department Oversight Act. While our report relies heavily on what was occurring and what occurred in New York, but it is not just a New York problem. We cite many situations in other states, in other cities. I'm sure that wherever city and whatever state that you represent, that you're aware of situations and incidents that have occurred in your own jurisdictions. Eliminating discriminatory profiling is but one step. We must move back to a place, or move to a place, of mutual respect. Respect for law enforcement, respect for community, respect for law enforcement to have for community, and respect for the community to have for other members in the community. Officers need to be taught other ways to diffuse a situation rather than implementing a permanent solution to a temporary problem. Our children cannot be viewed as being other than that, children and human beings. They must not be considered targets and they're not born suspects. Thank you.
Questions from the task force?
Senator.
Thank you. Thank you, Madam Chair. Thanks for your testimony. I did spend some time reading your report, and you focused a lot on New York. So I guess my first question is, of the number of stop and frisk, how many of those police officers were white? How many of them were black? Or can you give us the racial breakdown of who was actually doing the profiling or the stop and frisking?
Okay. Our report doesn't get into those kind of specific details because a lot of times you can kind of Google that information. And the reason why the report focuses in so much on New York is because New York had spent about 10 years with building coalitions in order to get to the place where they're finally able to pass that anti-profiling law. But I also thought and recognized that when the young man Eric Gardner lost his life, they did have a racial profiling law on their books, and that didn't stop that situation from helping. So that's why I say just passing an anti-racial profiling law is not an end and be all in and of itself. We've got to do more, but it certainly is an important step. And if you don't have one, it certainly can be your first step.
Okay. Follow up, Madam Chair. Okay. Also in your report, you cite Terry versus Ohio when it comes to the stop and frisk law that the Supreme Court ruled on back in 1968. And then you talk about the New York stop and frisk law. Can you, and by the way, you also went down to say that in a 2013 report, many of the police officers and police department did not meet the reasonable suspicion to actually do stop and frisk. Can you tell us whether or not you have specific numbers of how many people or how many cases met that standard, the reasonable suspicion standard, and how many did not?
Yeah, and that's the whole problem with with the situation is that a lot of law enforcement agencies are not required to do any type of reporting. Right now, ProPublica came out with a statistic that African American males were 21% more likely to be killed by police than their white counterparts. And that data was not, I don't want to say outdated, but it was over a span of time, but it was many gaps. It was missing many gaps because there is no mandatory reporting for any of our law enforcement.
Mr. Cole.
Thank you. You have to excuse me, you may have answered my question. I'm having trouble with some of the hearing down here, but could you give me your very good definition of racial profiling so I know exactly what we're talking about? And then could you contrast that with criminal profiling?
Sure. Racial profiling is defined, at least it is in our report, as, it's kind of like it's on our first page actually, and I kind of had lifted it out. But it's considered targeting individuals as suspicious based on a set of characteristics they believe to be associated with a crime rather than credible evidence or information linking that specific type of person to a specific criminal incident. So a crime has been committed, you see a group of Hispanic kids or Latino kids walking down the street and you stop and question them. Although the description that may have come over the radio might have said that it was a mixed group of kids, wearing, certain colors, but you identified these kids just because they're in a group. And so that's that's racial profiling. It has nothing to do with what was reported on the radio, so who you should be looking for to address this particular crime.
Was it Ms. Bell and then the bishop?
Thank you, Madam Chairman. Have there been any studies done, or is there any information on states that have enacted the laws against pretextual stops or racial profiling?
Absolutely. All of the states who have any type of law that speaks to that is found in the back of our book. That's how I found out that before we did this report that Indiana and Ohio were not listed, so they have absolutely no type of law that addresses this in any way.
So in the states that actually have the laws, have there been any studies done on whether there are less police complaints or any studies on the treatment of minorities in states that actually have taken those steps?
Okay. To my knowledge, there have not been, but I really don't know. I do know that of the states that actually do have racial profiling laws, they fall short of being the model law that NAACP believes having all of the characteristics of being an effective and efficient law. And we even provide a model law in here, a model statute to be enacted.
Along those lines, are there any renewed efforts to to go further with the End Racial Profiling Act?
Yes, there are. It's been introduced every year, by Congressman Conyers. And I know that has been on the table because I kind of Googled it. In 2013, it was introduced again. So that is something that we continue to work for, in an ACP on our national level.
Thank you.
Bishop.
Thank you, Madam Chair. Ms. Bowling, you mentioned that there was a lack of respect for members of the community and a lack of respect for law enforcement. Do you see that lack of respect in our society as an underlying problem? And could you say a bit more about that, about what we can do to try and change that respect so there's respect on both sides?
Okay. We've got to, well, one thing that goes toward building respect is to getting to know people. So police officers have got to know the community in which they serve. They've got to coach Little League so that they get to know the children. And when the children grow up and they encounter them, they're not afraid of them. Because a lot of, when you don't know somebody, then you have this unreasonable fear. And that's on both sides. I can remember, growing up and, coming to my school in elementary would be, police officers, officer friendly. The days have gone by from officer friendly, but, they came there and let us know, okay, well, as a little kid, this is somebody, we can go to if something happens, for assistance. But when the incidents that have continued and repeatedly happen in high profile negative incidents, then we start to know that instead of we're having the police officer come to our schools. Now we have to have sessions with our young people. We have a little pamphlet that we put out called the 411 on the 5-0, where we now got to teach our children what they must do whenever they encounter law enforcement. Because we tell them, so basically you're telling them that you need to be afraid of this person. And with, good reason. So.
Madam Chair.
Senator Roberts, and then we're going to go to Dr. Dunn.
Thank you, Madam Chair. Just comment before I ask a question. Ohio has had, at least on 2 different occasions I'm aware of, racial profiling introduced. I think Peter Lawson Jones introduced it the first time in the mid-90s, I believe, and it didn't go anywhere because I think we were convinced, or the legislature was convinced, that there was already a reporting process. I think that the sheriff's office has to do with the Attorney General's office already. So just so we know, the General Assembly has taken up racial profiling in Ohio at least 2 different occasions, but I'm aware of one with Peter Lawson Jones. But I would like to ask a question in regards to the Civilian Review Board and the cities that have those. Could you tell me a little bit more about their authority and how effective they are? Because I think several states or several cities in Ohio have looked at that, but I don't think we have the teeth they need to have. And so would you talk to the task force a little bit more about having civilian review boards and the authority they should have to be effective?
And that's true. In order for there to be an effective citizen review board, it does have to have the teeth. It has to have subpoena power. It has to have independent oversight over what happens with respect to the cases that come before it. For them to just have no power, they're just sitting here, kind of reading over the report, and there's nothing. They can see that there may be blatant problems with actions that had taken place with respect to police actions, but if they have no way to bring anybody in to speak to them, if they have no way to direct that certain actions, serious actions take place, then they're wasting their time, and they're wasting the taxpayers' time as well. So it's got to have teeth in it.
Thank you, Madam Chair. Follow up to that. And once the Civil Review Board is finished, where does their work product go to? Does it go to, what body does it go to from there?
Again, it all depends on how it's set up. I would think that it would go to, I would liken it as on the same level with, say, in internal affairs, When an internal affairs completes their investigation, it goes to, I don't know if it goes to the mayor, chief of police, or whomever, but the same person, wherever an internal affairs investigation report would go, I would think that the Citizens Review Board should be on that exact same level so that that report goes to that person. And that way that person has the benefit of two different views of a situation.
Thank you, Cabinet.
Dr. Dunn?
Thank you, Madam Chair. Ms. Bowler, thank you for your presentation. I've actually written a book on racial profiling. I actually completed my dissertation on the subject, and the infamous traffic cameras, which the legislature overturned, that was actually a recommendation of my research to address the racial bias found in traffic ticketing patterns in the city of Cleveland. You made reference to Terry v. Ohio. Our honorary co-chair, Congressman Stokes, actually argued that case before the U.S. Supreme Court in 1968. It's unfortunate he's not here to hear you discuss that, because we've had conversations about that case, and basically he was presenting an argument then in 1968 of racial profiling. And the incident that led to that actually stemmed from an incident in the city of Cleveland, which was actually a block away from my office at the university. You mentioned the need to transform the relationship between the police and the community, particularly the African American and minority communities. I suggest that racial profiling legislation will help lay a foundation within which we can begin to build a bridge to help bridge that gap, that gulf that exists between the two. I'd like to hear your thoughts on that.
Whatever we can do to try to bring parties together, whatever you can do to bring law enforcement into the community and not in a crisis situation. If communities are having block club, or what do you call them, block parties or something, you know, if they're having that, then, you know, why can't law enforcement kind of stop in there as well? Not, you know, as trying to see who they can harass or to take down license plate numbers, but to be a part of the community. I mean, if you're going to be policing this community, you got to be a part of that community. You cannot police a community in a vacuum, because at that point you don't respect them. You feel that you are a jailer at all times, and if they get out of line, then you got to punish them. You know, and that is not their role. And so that's what they've got to see. Their role is as protecting, and you can protect better if you are a friend of the community and people know that you care about them and that you have their best interests at heart.
I know Representative Reese has a question. I want to just, before I turn it over to Representative Reese, Madam President, thank you for your work, and to just add to what Dr. Dunn has said and Senator Williams, we have been working on racial profiling legislation for quite some time, to go back to what Senator Roberts had said. And in your opening, in some of your remarks, you talked about how in New York they were able to build the consensus. Because what Senator Williams and I ran into, and I'm sure Dr. Dunn was very frustrated by that, and others in Cleveland, working with the Cleveland NAACP, is the whole sense that the moment you introduce racial profiling like legislation, you are automatically anti-police. And Senator Williams and I wrestled with that for quite some time, trying to figure out ways to build the consensus, because you can have both. The citizens in this room tonight, citizens in Cleveland, citizens across this state, respect the police, want the police, but at the same time, they want to be treated fairly. You can have both. But that whole notion of racial profiling just triggers something in many law enforcement agencies. And I'm not saying that they all don't like it, but that was one of the biggest hurdles we had as we were trying to advance racial profiling legislation. And we didn't just want to introduce it for the sake of introducing it, back to your point. We were very deliberate in trying to get consensus, and we could never totally get it. And, you know, had decided that we were going to go ahead and introduce it anyway, but we didn't because you got to have buy-in from the law enforcement agencies as well as the community to get it to work. Because it's not just about introducing the legislation. We wanted it to be passed by the legislature, and we wanted it to work. So any advice or observations on how to surmount that hurdle that if you want racial profiling legislation, you are automatically anti-police?
Good comment. Law enforcement officials who, who do a good job in the majority, and I sincerely believe the majority of them do, want to do the right thing, know that things are not right, oftentimes in their departments. Like this officer that I singled out, he knew that things weren't right. He knew that, giving quotas on stopping people just to stop them because you got some quota to fill, because you got some grant from the government, and so you got to comply with that. He knew it wasn't right, but when it came to finally, it was a straw for him for a 13-year-old boy who he knew was innocent. So we've got to be able to get police officers to be honest with themselves and to have some self-integrity to say, if you need to help us help you. You know that it's not right. You know it's not right. You don't want it. You don't want to be a part of a wrong situation. But it takes a lot of courage to stand up and buck the system. So therefore, if you work with us to say that this would be safer for you, anytime you have the community working with you and respecting you and supporting you, then it's safer for you. You won't have a situation where innocent officers are sitting in their cars and somebody comes and just shoots them just because you're angry with some officers who you're never going to even be able to reach. So it really is in their best interest as well to see that this is passed, so that you can call the officers who don't do right. You can get rid of them.
Just a follow-up to that, Madam President, do you know how long it took from the time electeds and activists and other people who really cared about pushing, because if New York can do it, my goodness.
Mm-hmm. I would say I think they were in like a 10-year campaign, but again, we're all saying, we keep saying, we're all guilty of saying racial profiling, but it really should be called discriminatory profiling because it affects not only the African American community, the Latina community, the LGBT community, transgender, racial, sexual identity, anybody who is just targeted because of who they are, it's wrong. So we have to, and like I say, I'm guilty too, we have to change our terminology and say discriminatory profiling. That has to stop.
Thank you, Madam President. Representative.
Thank you, and thank you for your leadership in this report. You mentioned in your report Cincinnati, which is where I'm from, and Reverend Lynch, who's on the task force, also from Cincinnati, did a lot of work in terms of racial profiling in Cincinnati, the largest lawsuit in the history of the United States. And it can work when everyone comes to the table. Now we have a very good relationship with the police. There's been incidents, and it's been transparent, and the community is working together with law enforcement and the community. But I wanted to ask you about the Citizen Review Board and expand on what the Honorable Tom Roberts had to say about it. We have focused kind of on a city cluster, so Cincinnati's gone through its issue, and now Cleveland's going through its issue, and sometimes the urban cores are able to have these, as a result, review boards and different things. And then when you say born a suspect, since we're at Central State, we're always, there's always said they fit the description. But it has now transcended beyond the urban cores. It used to be just in the urban cores, in poor neighborhoods, poor communities, these kind of things are happening. But now it's spread out where they have no boundaries. In Yale, for example, my college mate, who is a distinguished writer, his son they said fit the description in Yale. They detained him and they said it was no longer him. We had an incident here, John Crawford, we're in Beaver Creek. We weren't in Over the Rhine. So can you tell us a little bit about maybe the importance of expanding, you know, like you said, the local areas have, you know, we got anti-racial profiling legislation in Cincinnati. We've got Citizen Review Board. Can you talk about now getting beyond the borders, because a lot of these things are happening in areas where maybe the person does live or doesn't live. You know, Trayvon Martin, we're talking about gated community. Eric Garner talking Staten Island, not Brooklyn or the Bronx. Can you talk a little bit about how maybe this is important to have a statewide Citizen Review Board, or do you see that having value?
Okay. That's why I was encouraged by your your task force being convened by the governor, because when you legislate something on the state level, in your state legislature, then it transcends across every corner within your community, within your state. And you don't have to do it city by city by city by city, which is what you're doing, you know, now. So I think that when you make your recommendations to the governor as when you finish all of your hearings, then maybe that can be a part of it to outline that each community must have a citizen review board. And these are the things that the Citizen Review Board is empowered to do and what they do. And let me tell you that just in Indianapolis, there is a Citizen Review Board what do you call it, organization. And it was, and the founder of, I think it's an African-American one, but the founder lives just in Indianapolis. We had our state convention and we had one of the people who are on the board. They can get, you know, and they have their conventions every year, but they can serve as a resource for you. And I can get that information for you, and maybe you can reach out to get some more information from them if you're interested in citizen review boards. But they've already done it, so you don't have to reinvent the wheel.
Dr. Dunn.
Thank you, Chief Bourne. In regards to civilian review boards, guess what? I've done a study on them too. Okay, the city of Cleveland has had one since 1985, so it's been in place for quite some time. But review boards in and of themselves, Cleveland's was found to be ineffectual. Okay, it's more symbolic than substantive. And the thing is, there are a lot of issues and concerns there as far as the appointments and who they're made by and things of that nature. But what has been, and the organization I think you were referring to is NACO, National Association of Civilian Oversight of Law Enforcement. I am a member of that body, and one of the foremost authorities on civilian oversight and police oversight is Sam Walker. He's a native Clevelander, and he's now emeritus professor at the University of Nebraska. And I submitted his name, hopefully, to present to this board. The more effective models have been found to be the police auditor or monitor model of oversight rather than the civilian review board. Those came out of the 60s and the civil rights movement. So in regards to something at the state level, I think you would be thinking of something along the lines of an IG, an inspector general, to monitor police actions or complaints. Not necessarily complaints, that's the day-to-day complaints that come in, but what the monitor or auditor does, they look more at the patterns and practices to reform the police agency and the practices of that agency, and to inform training needs and things of that nature. So they take a more broad, long-term view versus the handling of the day-to-day complaints, which is important, but what you need is the complaint system should serve as an early intervention or early warning system that management uses to identify problem behaviors before they reach a critical point. So just wanted to share that input.
Right, and I do agree, but as we say, you know, all politics are local. So you've got to make sure, because, you know, I can be concerned about what's happening in Cuyahoga County, and I can be concerned about Franklin County, but if I'm living in, you know, Butler County, then I'm concerned about what's happening in Butler County or whatever. I just heard some of those counties mentioned here, so I have no idea, except Cuyahoga. I know that because I lived there for 2 years. But all these other counties, I just heard the names today, and I'm pulling them out. But yeah, you got to have that. You got to have that local.
Representative?
Thanks. Well, reference is made to Butler County. I better speak up. That's where I'm from. But you know, this is very enlightening to me. I'm learning a lot from this task force about bias and racial profiling and problems that no doubt exist. And there's no question that legislation could be addressed on a statewide basis. But and you commend the panel even existing. You commend our governor for that, and I do too. The discussion that's taking place here on a statewide basis, it seems to me would be very, very productive on a local basis. And I mean down to the municipality, or could be county even, but even that might be on a large scale. I know in my little district I represent 4 municipalities, and it seems like if there may be some short-term steps we could take here, but long-term, it seems that this discussion that we're having today needs to take place in my 4 municipalities, and frankly, every other one that exists in the state. Because we want to build community and respect, as the bishop here has said. I don't know how you do that without regularly engaging in the conversation amongst people who don't always agree. It seems like it's really a local, politics is local comment. It seems like, to me, that's the long-term fix here.
Well, again, the report centers on New York City, not New York State. So you can do these things, you know, in your own community, your own municipalities.
All right, thank you very much. Thank you so much for joining us here this evening. It's a pleasure to hear your presentation. We are going to take a short break.
Thank you.
Thank you. We're going to take a short break and reconvene at 6:20, and that is when you will have an opportunity to share your thoughts and comments with the task force. I would urge you, if you have not previously signed up, to go to the desk that you passed when you walked in and sign up so that you will be able to participate in the public comment period.
Mr. Chairman, point of personal privilege. Oh, I'm sorry. Senator Carlton. I'd like to introduce several people who are here for the panel to know. Mrs. Sybil Edwards McNabb, the Ohio Conference NAACP chair lady. And sitting next to, thank you. And sitting next to her is the local Dayton NAACP and state board Vice President Derek Forward. I think I see Royal Mayo from Steubenville sitting back there. He's also a member of the state board. Thank you, sir.
Thank you, Senator. We'll be in recess till 6:20.